Good afternoon, everybody. Good evening, good morning, maybe for some people. Thank you so much for joining us this afternoon to talk all things pay equity and transparency. My name's Alison Treliving. I'm the co-global head of the Labour and Employment Group here at Squire Patton Boggs, and I'm delighted to welcome you to our second webinar of 2024 as part of our Global Board Series, looking at all of the key challenges and opportunities for global companies when dealing with pay equity and transparency. I'm absolutely delighted today to be joined by my fabulous panel. We have Jill Carilla, who is one of our partners in our Columbus office. Jill is going to cover everything from a US perspective. We are also joined by Nicola Martin, who is a partner in our Sydney office. Don't be fooled by the Scottish accent. She just likes to play tricks on us all. We also have Marga, who's from our Brussels office, who is going to look at the whole of continental Europe because she's just that talented. And we also have Jeanette Lucas from our London office, who is going to talk all things UK. I think one of the issues that comes up quite regularly, particularly when looking at these kind of issues across the globe, is all the different terminology. So we have pay transparency, pay equity, equal pay. So Jan, if you don't mind, can I come to you and can you just give us a bit of a noddy's guide? What do we mean when we're using all of these different terms, and do they actually all mean the same thing?
Yeah, of course. So the simple answer to that is no, they don't mean all the same thing. But rather unhelpfully, at least from a UK perspective, there's no statutory definition of most, if not all, of these terms. So it's sort of the common sense definition, if you like. So pay transparency, what that really boils down to is employers being open and clear about what they pay their employees and why. And that's not just from the point at which they are recruited, but it applies as much to the decisions that you will make during the course of their employment about what you pay them, whether that is how you set your pay bands, how you position your employees within those bands, how you apply pay reviews, bonus awards, really any decision that you make about pay and pay related benefits. Of course, here, historically, the tendency has been to be very tight-lipped about pay, with employers essentially imposing pay secrecy clauses, rather taking the position that pay is confidential to each employee and should stay that way. But I think for a whole host of reasons, we're seeing a real shift towards much greater transparency, both legally and culturally, with pay secrecy being seen as a real barrier to pay equity and also to efforts to reduce the gender pay gap. What do I mean by that? Well, legally, we have seen legislation requiring certain employers to report on their gender pay gap, which we've had for a little while now. We're also seeing pay ratio reporting requirements in some cases as well. For example, CEO to workforce pay ratios, all of which are really designed to force a greater degree of pay transparency and I guess encourage more open discussion and conversation between employee and employer. Culturally, I think we're also seeing a generation of employees who are much less tight-lipped than they have been historically and are much more willing to both start those conversations but also hold employers to account. So what do we mean by pay equity? Well, really that's about fairness in pay. And in the UK, at least, there's no legal right to fair pay as such. But of course, we do already have statutory protection against discrimination in pay under the Equality Act, which provides for both equal pay for men and women doing equal work, so that is gender-based discrimination, as well as protection against direct and indirect discrimination in pay on the basis of other protected characteristics such as age, race, religion, and disability. So in that sense, pay equity is not the same thing, although I can see an argument to say that if there is a lack of transparency and a perceived lack of equity in your approach to pay, there's potential for that being argued as the basis perhaps for an adverse inference in a discrimination claim. And we've talked for a while now about the fact that gender pay and equal pay are not one and the same. And I think that's a really important thing to bear in mind as we hear more this afternoon about the new European Pay Transparency Directive. As well as some of the politicking, if you like, that we've heard about our very recent general election here in the UK, because there does seem to be a degree of confusion or conflation of the two terms where I really don't think there should be. They're linked, yes, but they're still two distinct concepts. So I guess that brings us on to what's driving the interest here and why does it matter to boards? Well, taking those 2 points together, I think, as I've already mentioned, there is both a legal change in the landscape as well as a cultural change. And particularly for global businesses where the requirements in different regions and different countries within the same region can actually differ quite significantly. And that means that it introduces a real complexity that global organisations need to at least consider, and we'll come back to that a little bit later. But I think probably the bigger issue for us is the fact that there's very much an increased focus on ESG. And of course, you can see that pay equity and pay transparency plays both into the S and the G. Which means it is very much a focus for a whole range of different stakeholders, not just your employees, but it could include actual and prospective investors, customers and clients. Certainly it's something that we are being asked more about by our prospective clients, as well as employees. So I think for all of those reasons, pay transparency and pay equity is, or at least should be, very much on your board's agenda.
Sorry, just couldn't get myself off mute then. Thank you for that great introduction, Jan. Really appreciate it. I suppose just coming very quickly to the other panelists, do the terminology that Jan's describes, certainly from a UK perspective, resonate with you, or are there any differences or nuances in your particular jurisdiction? Maybe I can come to you first, Nicola. Is it the same terminology in Australia?
I think Jan makes a very relevant point in terms of the idea of conflating gender equality or gender pay gap and equal pay. I'm not sure we really pick up and distinguish between the two in Australia yet. And I would say most of the work that has been done, and we're getting there, we're still on the back foot, I think, compared to what we might hear from Jan and Marga today, but has been definitely directed at gender equality when it comes to pay, not necessarily pay equity as a concept that goes further than gender at this stage. So I think in Australia, people would struggle to understand that the nuances between the gender pay gap and just the concept of equal pay more generally. But certainly pay transparency is definitely a concept we're familiar with and sounds like it's very aligned to the UK position. Yep.
And is the position the same in the US, Jill?
Yes, I think it's very similar to how Jan described the two differences, and our laws have kind of sprung up in the same way, meaning we've got one body of laws that really addresses the pay transparency requirements and the not inquiring into someone's past salary history, and then we have another body of laws that gets to the more of the pay equity and the audits and the disclosure to either proposed or in actuality, as in California, to the government agencies about that compensation information with respect to different whether women or other protected characteristics. So I think the nomenclature is very similar in the US, although it sounds to be a little more refined and understood perhaps a little better in the UK than it's sometimes referenced in the US.
I'm actually not sure that's necessarily true, Jill. I just think Jan's explained it very well. I'm not sure everybody else would agree, but I suppose now looking at maybe a slightly broader position in terms of the current landscape and where kind of each of the relevant jurisdictions or regions are in terms of current landscape and also future changes. And if I can come to you first, Margaret, obviously for continental Europe, we've got the Pay Transparency Directive, which is very much a hot topic and certainly something our clients are talking to us a lot about. And I know you're doing a huge amount of talking about it at the moment. Can you kind of give us a broad overview of what that directive involves and how companies are beginning to prepare for that?
Yes, absolutely. So hot topic, as you say, because we now have the Pay Transparency Directive that was voted last year, and the member states have until 2026 to implement the directive into national legislation, because that is the consequence of this being a directive, meaning that the different member states in Europe will have to implement this into national legislation. And so there is inevitably going to be some diversity among the different member states. But like Jan was explaining, the reasoning behind the directive is that there is still a lack of transparency on pay, and that is causing the gender gap that still today is quite present in the different member states. It's estimated to be at 13% still, but if you look at other benefits, for example, workplace pension, the difference goes up to 27%. So there is still a lot of work to do, and it's considered that the main reason is the lack of transparency. And so that's what the directive aims to do, is to introduce that transparency in the different stages of the employment relationship. So starting with the recruitment process, where going forward, companies will be required to inform candidates about the initial pay or the pay range that they can expect for the job that they will be applying for. So no longer sort of a guessing game where there is an imbalance in the level of information. You'll have to provide that information upfront to the candidate at a point where it is still useful in the negotiation. Inversely, you will no longer be allowed to inquire about an employee's pay history. So asking the question, what did you make, or what do you make with your current employer, will no longer be allowed going forward. That once the employee is effectively recruited, there is the counterpart of that prohibition to inquire about pay history is that you can no longer prohibit employees from disclosing information about their salary to their colleagues. You'll also have to inform employees about how pay is determined within the company and how pay progression is assessed. And you'll have to inform the employees that they have the right each year to be informed about their general level of pay and how they compare to others in the same category. And what is considered the same category is employees performing the same work or work of an equal value. And that notion in itself, we could do a webinar just on that. But it's considered that work of equal value is assessed on the basis of four criteria only. And that is the skills required for the job, the level of effort, the responsibilities that the employee has, and the working conditions. Only those four criteria will determine whether or not work is to be considered of an equal value. And so you'll have to provide information to the employee individually on where they stand compared to other colleagues performing work of equal value. I have just done something. So that is an individual right that the employees have. And as an employer, you have to inform employees every year that they have this right to receive that information. That's on an individual level. On a more, I would say, collective level, companies as of 100 employees will also have the obligation to do an annual, or depending on the size of the company, every 3 years to do a pay gap reporting, where you really go into the numbers and you inform the employees, the employee representatives, and also public bodies that will need to receive this information and will publish this on some website that is still to be determined per member state. But so report on the pay gap. So the average pay gap, the median pay gap. You'll have to divide your population into quartiles depending on salary, and give information on the percentage of women and male employees in each of these quartiles. And you'll have to give information as per each category among the employees. So very detailed information to be provided every year, every 3 years. And then if on that basis, it appears that there is an issue, and what is an issue is if there is a gap of at least 5% in one of these criteria that I described, then you'll have to go in even deeper as a company. If there is this gap of at least 5%, and there is no objective justification for this discrepancy, and also it cannot be remedied within 6 months, then you'll have to do a joint pay assessment. Joint meaning that you'll have to do this in collaboration with the employee representatives within the company. And then you'll have to dig even deeper into the numbers and into the causes for the discrepancies. And of course, also propose measures to remedy these and follow up on these measures taken. And then lastly, what the directive also aims to do is, in fact, create more litigation around pay equity, and doing that by making it easier for individual employees, but also employees who want to be represented by their union or by an interest group to go to court and claim the salary that they should have been entitled to, on the basis of that being the salary that their average male colleague is paid. And so there's a number of rules that will have to be introduced by the member states, simply to make it easier for employees to effectively go to court. So all of these measures to promote more transparency around pay.
I feel slightly exhausted just listening to all of that, and how employers are going to tackle that when it's, you know, a really new concept to some of those jurisdictions. So it is quite a worry and quite a lot of work. Just really briefly, I understand that there is the corporate sustainability reporting directive as well. Does that impact on this area too?
Yes, you could say that it's in fact different aspects of this duty to be more transparent, the duty for companies to be more transparent. Pay transparency is that duty to be more transparent towards your employees, whereas with the corporate sustainability reporting obligation, companies will have an obligation to inform through their annual reporting that they do. They will have to inform their stakeholders, the general public, on where they're at in terms of their ESG targets. And of course, as Jan was saying, one of those, the S, is very clearly linked to pay transparency, because as part of the social part in the ESG reporting, you'll have to report on working conditions and equal pay. So yes, they're very, very closely linked. There is a difference in terms of the scope, though, in the sense that the corporate sustainability reporting is going to be for the, at least in the first phase, for the bigger companies in terms of headcount, in terms of turnover. But gradually this will become more of a general obligation indeed.
Excellent. Thank you for that. So maybe, Nicola, if I could come to you next, because I think there has been new legislation in Australia as well. So where are Australia up to? What's the landscape there?
Yeah, thanks, Alison. So yeah, there's been a few developments probably over the last year and a half, which are bringing us probably slightly closer to the UK and Europe. I think we've still got a gap in terms of gender pay equity, in particular, and you know, Jan made the very valid point over the fact that gender pay and equal pay are not the same thing. I think we're actually quite good from an equal pay perspective, and I'll just touch upon the reasons why in a moment. But from a gender perspective, we still have a gender pay gap of around 21.7%, so significant gender pay gap. And so about a year and a half ago, we had the introduction by our newly appointed Labour government at that time, banning pay secrecy provisions in employment contracts. So employees now have a workplace right in Australia to either disclose or not disclose, the choice is theirs, any terms related to their remuneration or any other terms and conditions that go to financial benefits. And now for about a year, we've had the law in place, which actually bans employers from including those pay secrecy terms in employment contracts. So there was a transitional period where you could have them, but they were just ineffective. But now any new employment contract entered into after about June 2003 is actually in breach of our legislation. And so that was a big change for us. That was a significant development. And as others have mentioned, the idea being, of course, that by encouraging transparency and an open discussion about pay rates, it's hoped that employers will be prompted to ensure that employees are paid fairly, regardless of gender. So again, it was a gender pay equity issue that was driving those changes introduced by the Labour government. But as I think we all know, that pay transparency can be a polarising topic, and obviously we know there's benefits there. We know it potentially evens out the gender pay gap. We know it can save employees time when they're applying for roles and encouraging more suitable applicants. But there are the critics who say that it actually can increase unhappiness and cause conflict and cultural issues in an organisation. And I think that's something that the audience here today, who are all no doubt HR professionals or employment legal counsel, will be very familiar with. And so there were organisations in Australia certainly that weren't ready for it, and they weren't ready for the conversations, the difficult conversations, and some of the conflict that was arising with from the discussions that their employees were having. So we did quite a bit of work with employers in that particular regard. And then we also have, from a gender pay equity perspective and laws addressing the pay gap, from a gender perspective, we have our Workplace Gender Equality Act, and that's been around for a number of years. That act's been in place since 2012. But as you can see by the fact that the significant gender pay gap we still have, it's been slow to really make much impact in Australia. The baseline position is that all private sector employers with 100 or more employees are required to report annually to our Workplace Gender Equality Agency, or WGEA as we refer to it, on 6 gender equality indicators, which are gender composition of your workforce, gender composition of any governing bodies, such most obvious example being the board, equal rem between men and women, availability of flexible working arrangements, what organisations do to consult with their employees on gender equality issues, and sexual harassment, or reporting on sexual harassment or harassment on the grounds of sex discrimination. And so last year we had some expansion of the remit of the agency. And now the first reporting period is for the 2023 to 2024 reporting period. The remuneration of CEOs must be included in the reporting now, and there's also some increased requirements for reporting on sexual harassment complaints that have been made in the reporting period. In addition, there's a new obligation on employers who have 500 or more employees to actually have a policy or strategy in place to support each of those 6 gender equality indicators. So it used to be that you only had to provide evidence that you had a strategy around at least one of the indicators, and now that's 6. So increased reporting, increased accountability for those larger organisations. And so this year, with that 2023 to 24 reporting period, it was the first time that a number of different organisations had that increased reporting obligation. And the gender pay gap used to only be reported by the agency on an industry-based, so it was never organisation by organisation, it would just report on an industry-wide basis. So this year, February this year, we saw the naming and shaming happening for the first time when the agency published the results. And it was palpable. It was, maybe it's because we were a bunch of lawyers sitting in a law firm office, but the results came out. They were all over the media. There was a huge amount of attention given to them. There was naming and shaming of large organisations. In the legal world, there was naming and shaming of law firms. And that was something really new for us. And as embarrassing as it would have been for those organisations who didn't fare very well, it's definitely a significant step forward for us in forcing employers to look inwardly. So that's the gender equality side of it and the pay transparency part of it. We also have, when it comes to equal pay or pay equity, and this concept of just general fairness rather than that gender gap, we have equal remuneration orders. So our Fair Work Commission, which is our employment tribunal, either on its own initiative or on the application by an employer or an employee or a union, can make equal remuneration orders. And that is to address pay disparity within a particular workplace. We've had it for a really long time. The laws have been there and the powers have been there for our commission to make these orders for probably 25, 30 years. But the issue was that there was two major hurdles. Firstly, the employee had to show that pay disparity was caused by gender-based discrimination, to Jan's point. And secondly, a female employee needed a male comparator to establish gender-based undervaluation. So there was various applications and in over a number of years, significant cases in 2015, 18, 2021, where those equal remuneration claims were actually rejected by the Commission because the employees were not able to prove that the disparity was caused by gender or identify a male comparator. And so some of the amendments to our legislation last year went to address that issue. And those two hurdles have now been removed, and the Commission now can make the orders looking at has the work been undervalued on the basis of gender, and whether historically the work's been undervalued on the basis of gender. And it's now appointed expert panels to look at various industries and occupations. We've only had one example of an application being brought since the changes in the law. And unfortunately, it was brought by a female who was, by the time she made the application, a former employee, not current employee. She was a chef and she was arguing she was paid about $15,000 less than her male comparator. But the Commission said, I think with some reluctance, that it couldn't actually make any orders and progress the claim because she was no longer a current employee. So that was definitely a limitation in the legislation. And just lastly, our Commission has already got an ability to make work value determinations. So that means that they can look at our modern awards, and our modern awards are industrial instruments. They're almost like collective agreements that apply to a particular industry or a particular occupation, and they set out the minimum terms and conditions of employment for a particular industry or a particular occupation. Part of the objective of the Commission in setting the terms of these modern awards is to ensure that they apply work value reasons. So reasons to justify the amount that an employee should be paid for doing work of a particular kind, taking into account the nature of the work and the responsibilities involved. And there have been a number of work value determinations made under various awards in the last couple of years. So, for example, the award that covered child care and child food educators, there was an adjustment of, I think it was something like 13 or 14% wage increase on a work value determination, and the same from direct care workers in the aged care industry. So we've actually got quite effective measures as part of that award review process to address inequality under the award review process that the Commission has. So I think it's fair to say overall, that was a long explanation, but we have work to do, but we're certainly in better shape than when we were even a couple of years ago.
Yeah, so there's a definite trend going across the globe at the moment in terms of where this is going. And Jill, if I can just come to you kind of quickly in terms of the US, and are you seeing the same kind of trends coming out of the US?
Sure, and I certainly won't try to summarize all of the states' laws in this area, but for sure it's been the states that have taken the lead on passing this type of legislation. The federal law has been the same. We've always had laws prohibiting discrimination in compensation based on protected characteristics, or we've had the Equal Pay Act, which prohibits differences among gender with respect to the same work. But the states have stepped in and started to say, well, that's not enough. We want you employers to take proactive measures. And of course, the state that we are not surprised, who's the leader, is California. And they started back in 2019 in this area, and other states have slowly followed suit. And the trends we're seeing, as everyone's really described here, is they take that pay transparency in terms of what you're required to include in job postings or advertisements, including when you use agencies to post for you. You have to make sure that you're including the range of compensation. But again, not to be the bearer of bad news, but for those of you who have employees or applicants that you are seeking in more than one jurisdiction, employers absolutely have to know the differences in those laws because they differ with respect to coverage. What information needs to go in that job posting? How do you know what's a good faith effort? So those are all the type of things that are addressed in the different statutes, and some of them are very similar, but others take a very different approach to what they cover. And then just briefly, on the other hand, on sort of more of the pay equity auditing type laws, I think it's very important, again, to note that there's about 10 states that have different laws with respect to their own pay equity and what's required. And it's important to know the difference because some of them stop at gender. So they just protect differences in gender pay. Others go a step forward or farther and include differences in pay based on other protected characteristics. And so it's not good enough just to follow the federal equal pay law. You need to look at the state's law with respect to pay equity and also the standard. Some of these, like California, the standard is for similar work, you have to pay the same. Whereas on the federal side, it's the same work. So it's a broader standard that you need to be aware of if you're going to be soliciting employee or applicants from those jurisdictions, whether or not you are based in that state or not. These laws can pick it up. So that's what I would add from the US side.
I think that's really helpful. And I suppose finally, last but not least, coming to you, Jan, in terms of the UK, obviously we've had gender pay gap reporting equal pay for some time now. I'll put two questions to you. You've got 30 seconds to answer each. One is, do you think that even though we're out of the EU, we'll be impacted by the Pay Transparency Directive in Europe? And I suppose adding to that, do you think the outcome of this week's election, was it this week, last week's election, is going to have any impact?
Okay, so very quickly.
I'm timing you on your 30 seconds.
Yeah, in terms of what it means for the UK, I mean, we're obviously, the directive is not binding on us, so we don't have to do any of this. And my real nervousness comes around the equal pay and the equal value terminology, because although what Margaret describes comes directly from the Equal Treatment Directive, which is the basis for our equal pay legislation, I think something people don't always appreciate is you can have two very different jobs that are measured. So on the face of it, they don't look the same and they don't look similar, to Jill's point, but they could nevertheless be valued equally when you take criteria based on effort, skill and decision taking. So that's, and I think we'll come back to that a little bit later. But in terms of, do I think anything is going to change with the Labour Party having been elected? Probably not. I mean, there is talk about extending the equal pay regime to include other protected characteristics. My personal view is unnecessary because we already have that anti-discrimination protection there. So the only other aspect, which I think is a differentiator for us compared to Australia, Europe and the US, is the extent to which pay structures are built into collectively bargained arrangements and, industry applicable collective agreements, because there you have designations in terms of categories of jobs. And I'll be interested to see whether or not, from an equal value perspective, for the purposes of the directive, those classifications are used or relied on in some way. And I guess that's a TBC, because we're waiting for that guidance. So a little more than 30 seconds, but there you go.
You'll be penalised later, it's fine. So Margaret, if I can come back to you, as I said earlier, you've been doing a huge amount of talking to clients around the new directive and what it means, but kind of listening to what everyone's saying, we can see obviously changes around the world. What practical advice would you give to employers about if they're looking at reviewing or reshaping their pay policies or practices at the moment? Is there some practical advice that they can rely upon at the moment?
So as you say, we've been doing a number of these sessions with clients, and I would say the consensus near the end of those is always that clients decide that what they need to do and what they need to do now is because today we still have 3 years before that first report has to be issued. So there is still some time. And one of the first things that clients say that they need to do now is have a look at their job architecture or their job grading, as they hopefully currently already have it in place. If not, then now is really the time to get it in place, or potentially to get it updated if it no longer meets the requirements, because that job grading is going to help in terms of assessing that work of equal value, and is going to be the basis for the reporting that going forward will need to be done. So a close look at what's already in place in the company, and whether that still stands the test of the pay gap reporting. So basically running that grading through the machines to see what comes out in terms of when you are comparing, how does the company do? How bad is it, and in which areas do we need to do more work? And if from that assessment it comes out that there are issues, then the question is going to be, first question, can we justify any differences that we see? And that's been also an interesting exercise that we've been doing with clients, is when they are crunching the numbers and they see that there is indeed differences, is to look at what's the reason for these differences still being in place. Is this something that we can address? Is this something that we can justify? For example, one of the clients mentioned that when they were doing their numbers, they noticed that there is a big difference in pay depending on whether or not an employee has at some point in their career within the company decided to go on a secondment to another entity of the group, because the company as a group, as an international group, really supports those decisions to do international secondments. They will determine pay progression going forward. But what did they see in the numbers is that it's more or mostly the men doing these types of international secondments rather than women, whereas women at a certain point, when there is a family, for example, they're less likely to uproot the family to do this type of secondment. Now, is that in itself, for example, a sufficient justification for that difference to be there? So these kinds of questions the company will have to address, will have to provide an explanation and to make sure that it's backed up by the numbers. If there is discrepancies, now is still the time work on them in the next pay rounds that there will be until 2027 to address the gap. And also now I would say is the time to work on policies, because going forward, that's also going to be very important, is that you provide that information to candidates, but also to the employees once they're in service, is that you provide information on how do we determine pay, how do we evaluate your work. For example, in quite some companies still today, there will be an annual assessment, but there aren't really any set rules on how that should occur and how the result may impact salary, for example. All of these issues, if these are addressed in a policy, in an objective policy that can be shared with the employees, that has the support of the employee representatives, that will make the work so much more easy going forward. And also an important point of attention that we've noticed when we were discussing with clients is the issue of bonuses. Very often, base pay is still quite objective in accordance with pay grades, etc. Where you see that there's often still a lot of room for managers to decide upon their discretion, is specifically on variable compensation, and variable compensation will also be included in the pay gap reporting. So that's also an important one to tackle while there is still time.
That's great. Thanks, Margaret. And I suppose, that's looking at things very much in terms of the European perspective of it, but also kind of more practical, more globally. But what we often see clients is asking us whether they can take a global approach, not only to this, but to other issues. So, Nicola, do you have a view of whether you can, is there a one size fits all? Can companies take a global approach to this, and is it recommended?
I think it's complex. I think there could be a temptation to say, well, let's look at as lots of global organisations do. When it comes to privacy, when it comes to other legal issues, that they say, well, okay, let's look at the highest threshold. If that's the European directive, then we look at that and then we apply it globally so that we do have a one size fits all approach. But I think there's some real potential challenges with that. You hear Jill talking about the different states in the US having different requirements. How are you going to ensure you're complying with all of them? Do you want to have to apply the highest threshold throughout the globe if you don't have to? Moving towards a transparent salary model is a huge undertaking. And it's particularly onerous for smaller organisations. It's not a simple process. So, and some of you may not have organisations where there's even formal processes in place when it comes to job descriptions and position hierarchy and the like. So I think there probably would be a well-meaning intention to say, okay, let's take that highest threshold and apply it globally because that's the right thing to do. But it could become a much more significant piece of work than you perhaps think it might be initially. So with the best of intentions, it's something that needs to be given, I think some serious consideration before jumping into it.
Yeah, no, I agree. And it can become very, very tricky in terms of that. And I suppose that's when you start getting into difficulties in terms of risk and managing that, and as you say, going up to kind of the highest threshold, which is always difficult. I mean, we heard from Margaret earlier that behind the directive there is, the intention that there is more litigation. Jan, from your perspective, do you think there are risks to employers getting this wrong, and do you think, from a UK perspective and maybe more widely, we will see more litigation in this area?
Yeah, so I mean, to be clear, from my perspective, I think pay transparency can only be a good thing, and I think there are lots of things that UK employers and UK parts of a global organisation can still do in terms of improving the transparency of their pay processes. So looking at their pay structures, looking at the decision-taking process, looking at their pay bands, all to the good, not asking those questions about pay expectations, which historically have played against women in those sorts of negotiations, and then then set them up in the wrong way right from the off. All of those things I think are potentially doable from a UK perspective. The bit I'm much more nervous about is this whole equal value piece, as I've touched on before. And there's a couple of reasons for that. And I mentioned very briefly this idea that you can have two very different jobs that are in our world potentially going to score equally. And if it's the sort of thing which, if done properly, is done with experts, it needs to be done very carefully, etc., etc. But if not done in that way, you can very easily inadvertently get yourself into real potential difficulty. And I think the added complication for us here that maybe isn't such an issue in the US and on the continent is our rules around legal advice privilege and legal professional privilege. They are much more restrictive. And so there is a real risk that if organisations are having these sorts of conversations around equal value and doing so by email or in meeting minutes, all those discussions, those documents are going to be disclosable, and that could potentially create a much bigger problem down the line. But as I say, in terms of the transparency side of it all, we're already having those sorts of conversations in the context of the gender pay reporting, and those conversations should continue. But it's just that equal value, that equal pay piece that I think we just need to be much more cautious about.
Yeah, no, I would agree with that. And I suppose, Jill, just coming to you, knowing how litigious it can be in the US, have you seen an increase in litigation in this area? Do you anticipate that there will be more litigation?
Sure. I think absolutely we've seen a rise in litigation around more discrimination and compensation and Equal Pay Act violations, which we've seen before, but there's definitely a rise in that focus of the discrimination. What we haven't seen yet, but we suspect is coming, is a lot more litigation over these pay transparency laws. And not even so much, it's because if you're not doing it as part of your policy and you're violating the law, we've got plaintiffs' attorneys sniffing around for those type of violations because they impact more than one applicant, right? They implicate a bunch of people in the same category, and that spells out class action ripe, and that means big dollars. And so we are preparing to see more litigation. I will say some of the states have differences, and if you have a violation, they give you like you can mess up one time, and the second time you get a fine. But many other states allow the applicant or employee to go straight to court, do not pass go, and that's when it can really get expensive for employers. And so, one of my practical takeaways is similar to what Jan was mentioning is if you haven't done it yet, and this isn't on the pay transparency compliance, but more on the, you already can get sued right now if you have a problem. But if you know about it and know about it in a privileged manner, which you are still able to do to a large degree in the US, you can set up a pay audit and do so largely in a privileged way so that some of those findings don't have to be made public where it may show there's a discrepancy in pay that's not explainable. And it's the way in which you structure that privileged pay equity. Now, not the facts all the time. You're not able to keep that privileged, but largely that is going to give you a cover. And so from my perspective, if you think there could be a problem or you don't know, to look into conducting your own audit, and it can be done in a very economical way and help you spot these issues before you're on the other side of a plaintiff's lawsuit that says you're not compensating protected classes equally.
Yeah, and the privilege point's an interesting one because that is a real contrast, and certainly in some of the matters I've been involved in where the client has started in the US, a global client started in the US, have done that exercise in the US, then come across to the UK to say, right, we're ready to do it here. it is a different landscape. Nicola, from your perspective, what's the privileged position in Australia? Would doing that kind of fact-finding audit attract privilege?
I think it would be hard to attract it at the fact-finding stage. Yeah, I mean, as a lawyer, even if you've got your lawyers involved providing advice on the actual data, who's actually doing the audit itself? I mean, we as lawyers wouldn't usually do that, and in-house counsel wouldn't usually do it. So I think there would be some challenges. I think the position sounds in Australia like it's probably more similar to the UK.
Yeah. Okay. Well, I'm conscious of time, and so I suppose it's a good time for us to kind of get key takeaways. And Jill, I know you just started with one of your key takeaways in terms of kind of getting your ship in order. Mark, if I could come to you, do you have a kind of key takeaway from the session? One piece of advice or two pieces of advice that you could give the audience in terms of what to do around this?
I think it's going to be important to have these discussions with management and to make them aware of what's coming. Because people in HR will be aware of the fact that going forward we should avoid clauses in the contract that prohibit disclosing information. They will know that we can't ask questions about pay history, etc. But very often in larger organizations, the people who will actually be dealing with the candidates, with the employees, won't necessarily be aware of that information, won't necessarily be up to speed, might also be located in other jurisdictions while they're having the interviews. Whereas, for example, in Europe, quite likely we're going to have a diversity of legislation in the different member states. So it's going to be important to have the conversation with people, having the conversations with the employees and with the candidates to make sure that they are aware of this and that this is something that's going to take time. For example, inquiring about pay history, that's, I think, for many companies so ingrained in the process that it's almost second nature. So it will take time to remove that from the process. And as it will take time to introduce the necessary policies and to have these complied with by the different stakeholders. So I would say use that time to make sure that everybody is aware and knows what they can and cannot do.
That's great, thank you. And Jan, if I could come to you, your takeaways from the session?
Yeah, I think I would firstly just reinforce what Marga said. I mean, I think, managers are on the front line of these conversations, aren't they? And as we see in other contexts, if there's a misstep at the beginning, that can potentially have very significant implications down the line. But I think it's also, so keep the narrative simple for them and make sure they understand where that issue and how that issue needs to be escalated so that the right person can then help them navigate the way through it. I think that's absolutely critical. The second thing is, again, to Marga's point, embedding these behaviours. There's no reason why you couldn't say to your recruitment team, wherever they are based and whichever countries they deal with, that we stop asking these questions now, so that by 2026, that behaviour is totally embedded in it. It's completely natural at that point. And, I don't see any harm at all in us starting and being very, very proactive in that. I think the other thing from my perspective is that we still, from a UK point of view, we still do the gender pay reporting. You can still get a lot of information, insight about what's going on within your organisation from a pay perspective from that analysis. It's not an equal pay analysis. Average pay tells you nothing as far as equal pay is concerned, but it still gives you an indication of where the barriers are likely to be. So continue with the sorts of measures you'll already in many cases be talking about in terms of, consider promoting effective sponsorship of women within your organisation by senior leaders in particular. You might think about equalising parental leave rights for men and for women. You might think about having some moderator and board so that there's an extra pair of eyes over pay review decisions and bonus awards. I know there's a lot of conversation around gender balance shortlists. Obviously, from a UK perspective, positive discrimination is not permitted in the same way as it is in the US, for example. And so there's an element of concern there. But there are already things that we can be doing that will start to shift the gender pay gap, recognising also that there are some issues that are societal. We're not going to be able to change them overnight. And I think nursery and social care are two increasingly big obstacles to progress, because, I think there's a generation of women out there who have both sets of responsibilities these days, and it is an inhibitor. It can, or it certainly can be.
Yeah. Thanks, Jan. And lastly, if I can come to you, Nicola, your key takeaways from today's session.
I would echo what all the rest of the panelists have said, and something specific to Australia that I would encourage any of you who are on the call who have Australia within your remit to look at from a gender pay gap perspective is superannuation. So superannuation is basically our pension. And an employer has to contribute a certain amount of an employee's base salary into their superannuation fund on a quarterly basis. And where we see a significant issue that needs to be addressed while addressing the gender pay gap is the fact that those payments don't have to be made whilst an employee is on parental leave. And the best practice now will be for an employer to continue to contribute to the superannuation fund whilst specifically females are off on parental leave, whether they're receiving an enhanced company-funded parental leave payment or whether they're not. The best practice employers are now continuing to contribute superannuation whilst female employees are on maternity leave. So I think that's a really important point to think about if you've not already thought about it for your Australian employees. And secondly, this concept of pay secrecy clauses being banned, the right to discuss your remuneration or not discuss it, as the case may be, is now a workplace right for the purposes of our general protections legislation, which is effectively a regime that prohibits retaliation or victimization because an employee exercises a particular workplace right. So that right to talk about remuneration is embedded now in our legislation as a workplace right. So that's a key takeaway as well, just to be conscious that when people are talking about pay, if somebody comes to you with, for example, a complaint about their pay because they've been discussing it with a colleague, you have to be extremely careful that you don't take any sort of adverse action in respect of that employee because they've raised that complaint. And of course, 9 times out of 10, any adverse action you might take, whether that's performance management or termination, the employee will claim it's because they've exercised their workplace right, whether the two are connected in any way or not. So just something to look out for that's specific to Australia.
Yeah, and another point around kind of that education and making sure managers are aware of the position. That brings our session to a close. Thank you very much to everybody who has joined us today. If you've got any questions about anything that we've discussed today and didn't get a chance to put them into the Q&A box, then please do drop us a note. We'd love to hear from you and love to hear any feedback. And as I said at the beginning, we will be circulating a recording of today's session, so look out for that in your inbox. Thank you to my panelists today for all of their wise words and insights, and I hope everybody enjoys the rest of their day. Thank you very much.